Good afternoon. I think we're ready to get started. I'm Tara Morrissey, and I'm pleased to kick off our next session. We will be having a roundtable discussion to explore the renewed debate about the propriety of nationwide injunctions and the more recent phenomenon of nationwide TROs. Do these remedies exceed the Article III power of federal courts, or are they necessary to afford parties full and fair relief when confronting federal action? We're fortunate today to be joined by Judge Lawrence Van Dyke, who will moderate our discussion of this important and timely topic. Judge Van Dyke has held leadership positions at the state and federal levels. At the state level, he served as Solicitor General of both Nevada and Montana. At the federal level, he was Deputy Assistant Attorney General at the Department of Justice. And of course, Judge Van Dyke currently serves as a judge on the U.S. Court of Appeals for the Ninth Circuit. Judge Van Dyke, thank you so much for joining us today. I'll turn it over to you.
All right. Well, thank you, Tara. So I hope you all are as excited about today's panel as I am. A very timely discussion we're going to have about nationwide or universal injunctions or whatever other adjective you want to throw on the front of that word. And we've got a panel of 5 people, so I'm going to introduce them very briefly and then try to get out of the way. And I think we actually are in order of how everybody's going to speak. So, and the format will be 5 to 8 minutes or so of opening. Then we'll have another round where everybody gets a shorter time to respond. And then I will ask a question or two perhaps, and then I'll open it up to audience questions. And my understanding was there's going to be, I see a mic right over there. So step up to the mics and I'll try to call on you. So without further ado, we'll be starting with Jesse Panuccio, who I've known since law school, but I won't talk about any of the stuff from then because you may want to get confirmed to something at some point.
It's a bigger problem for you than me, I think.
Jesse is a partner now at Boies Schiller, and he's a co-leader of the firm's appellate group, and he's the former acting associate attorney general in the first Trump administration, where we had the pleasure of getting to work together. And then after Jesse speaks, then Luke McLeod, who's a partner at Williams & Conley, will speak and maybe be responding to some of what Jesse says. He's a former assistant to the Solicitor General of the Department of Justice, and I asked whether we overlapped, and I don't think we did. I think he waited till I left to come. And then we'll be followed by Michael Morley, who's the Sheila McDevitt Professor of Law and Director of the Election Law Center at Florida University College of Law. And then Alan Trammell will be speaking. He's a professor of law at Washington and Lee University, where I get a ton of interns from. And then where his scholarship and teaching and focuses on federal court, civil procedure, and con law. And the last but not least, Tyler Lindley will be speaking. He's a professor at BYU Law School, and he will be batting cleanup in whatever form. So go ahead, Jesse. Take it away.
Well, thank you, Judge Van Dyke, for that introduction. Good to share a stage with you and with this very distinguished panel. Thanks to the Federalist Society for hosting this Executive Branch Review Conference again and inviting me back. I think it's a great conference. You know, Hamilton said, energy in the executive is a leading character in the definition of good government. And I would say that the energy of this particular executive is giving us a lot to discuss, particularly what we'll be discussing today and for conferences like this. Let me note at the outset, my views expressed today are my own, not of my law firm or any entity with which I'm affiliated. To that end, I would also note that while I personally believe non-party relief, which is what we'll be discussing in all of its guises, is beyond the judicial power as defined in the Constitution and properly interpreted, so long as courts are willing to do it, I can't fault any lawyer who seeks non-party relief on behalf of a client who desires it, and I would do so myself, so long as that is the law. I hope one day it won't be the law, but right now it is, and so I can't fault anyone for doing that. But the question for today's panel is not what is happening, but what should be happening in our federal courts. We're considering an issue, a problem by my lights, that is recurrent in our modern federal judiciary, namely the use of judicial power by federal district courts to grant relief to parties that are not before them. These courts have done so through equitable injunctions and through stays and vacatur under the Administrative Procedure Act. Such relief has been given various names over the years. You've probably heard nationwide injunctions or universal injunctions or even cosmic injunctions. I think these kinds of orders are more aptly named simply non-party relief. The term is not as catchy, but I think it accurately describes what these judges are doing. And it describes what's happening regardless of geographic scope or procedural vehicle through which the relief is granted. To my mind, the propriety of judges issuing non-party relief is a very important matter. It's a question at the heart of our constitutional republic. It's a question about democratic legitimacy and the American people's control of their government. And it's a question that asks whether our federal courts exist to decide cases or advance causes. It's a question about whether judicial independence can survive when unelected, life-tenured federal judges act like legislators or executive officials, or when they purport, as Justice Gorsuch once said, to govern the whole nation from their courtrooms. The statistics show that there is an ideological tilt to the judges who issue these orders, but they also show that the problem is nonetheless not confined to one president, one party, or one particular substantive policy area. Policies and practices that have been deemed critical to Republicans and Democrats alike have been enjoined or vacated nationwide by lone federal district judges, providing relief to millions of parties who never requested it and were not entitled to it. Accordingly, the Department of Justice, across administrations, has consistently argued that against granting relief to the parties in a case. Indeed, just a few months ago, before the change in administrations, President Biden's Solicitor General explained as follows, quote, "Universal remedies are inconsistent with longstanding limits on equitable relief and the power of Article III courts and impose a severe toll on the federal court system," end quote. And jurists on both sides of the aisle, at least at the appellate level, have been critical of these orders. Justice Kagan, in a 2022 speech, said as follows, quote, "It just can't be right that one district judge can stop a nationwide policy in its tracks and leave it stopped for the years that it takes to go through the normal process," end quote. Before I highlight the many problems with non-party relief, let me offer a concrete example and not one of the current controversies. Let's go back to the first Trump administration. In 2017, the Department of Justice imposed new conditions on law enforcement grants requiring participating local jurisdictions to cooperate with federal law enforcement to remove illegal aliens who had committed serious crimes. The city of Chicago, apparently not wanting to remove dangerous criminals from its jurisdiction, sued, alleging that the grant conditions were unlawful. The district court, quote, "granted the city a preliminary injunction against the Attorney General's imposition of the notice and access conditions in the burn jag grants, as they were known." But rather than stopping at providing this complete relief to the only party before it, the court held as follows, quote, "This injunction against the imposition of the conditions is nationwide in scope, there being no reason to think that the legal issues present in this case are restricted to Chicago or that the statutory authority given to the Attorney General would differ in another jurisdiction," end quote. Now, no other party was before this district court. Cases were pending all over the country in other districts, and Chicago could not make any claim that its own interests required nationwide relief. Yet the district court, with that one line of dubious reasoning, felt it appropriate to exert power over every other grant in the country and to preclude any other judge from effectuating a contrary conclusion. Now, what's interesting about this is that the Second Circuit Court of Appeals, a higher authority than the lone district judge in Chicago, would later find that these conditions were entirely lawful, highlighting how incredible it was for a lone district judge in Chicago to dictate the result in New York and everywhere else in the country. With this example in mind, let's highlight just a few of the problems with non-party relief. First, as Justice Thomas explained, non-party injunctions are legally and historically dubious. The Constitution grants to federal courts the power to hear cases and controversies, which the Supreme Court has long interpreted as the power to render a judgment or decree upon the rights of litigant parties only. Yet non-party injunctions afford relief to those not before the court and even those who don't have standing. In the Chicago case I just mentioned, there was an amicus brief filed by a number of cities that said not only did they disagree with Chicago's position, they didn't want the relief that was being requested. They wanted to comply with the grant conditions. And what did the judge do? He said, well, that's fine, I'm going to give you relief anyway that you have not requested and do not want. Now, some have argued that nationwide non-party relief is a necessary check on the ever-growing power of the executive branch's administrative agencies. But as with so many of the ills that arise from Congress's excessive delegations of lawmaking power to the administrative state, the answer is not to fix one constitutional distortion by creating another. Rather, if the concern is with the power of the administrative state, then the answer is for Congress to reassert its atrophied policymaking muscle, not to transform the judiciary into a third political branch. So that's problem one. There's no constitutional authority for these orders. Two, the second problem with non-party relief is that it undermines the norms, rules, and structures that undergird our multi-court, multi-jurisdiction, multi-tiered legal system. One such norm is the concept of percolation. Our legal system is premised on the idea that percolation of legal questions among lower courts is a good thing. It leads to fuller development of facts, a fuller consideration of arguments, and a fuller range of opinions from respected jurists across the nation. There are several legal provisions that reflect this, Rule 10 of the Supreme Court's rules, for example, but the most important one is the Constitution. It establishes one and only one Supreme Court, and such inferior courts, and that's what the Constitution calls them, inferior, as Congress may from time to time ordain and establish. In this hierarchical system, one district court does not bind another, and one circuit does not bind another. It's only the Supreme Court judgments that are binding on all federal courts. Yet nationwide non-party relief effectively has any one of 1,000 district judges wielding the same supremacy as the Supreme Court by stripping from other courts the efficacy of their contrary rulings. The nationwide non-party injunction thus simultaneously makes every court supreme and every court a potential nullity. Some argue that nationwide injunctions are necessary to achieve national uniformity and complete relief, but we have something else that does that. It's called the class action system. And the class action system has safeguards to ensure the appropriateness of class-wide relief, the adequacy of representation, the rights of non-class members and absent class members, and the rights of the defendant. The class action also equalizes the risk of litigation. The judgment is as binding on the class as it is on the government. Non-party injunctions whistle past this entire carefully calibrated system, sweeping in all parties, regardless of whether they have standing or even meet the requirements of Rule 23. And they permit the government no finality at all, and they don't bind the plaintiffs at all. The government must run the table, while plaintiffs can simply keep suing in court after court after court until they find one sympathetic judge who gives them the relief they want for the entire country, even if every other judge in the country would not. And the third problem with non-party relief flows directly from the first two. Because these orders have no basis in law, because they affirmatively flout several legal rules and norms, and because they cast aside Congress's authority to set the jurisdiction of inferior courts and the executive's authority to determine how to apply a lower court decision, it is, in the words of Justice Gorsuch, quote, hard to see how the court could still be acting in the judicial role of resolving cases and controversies, end quote. Indeed, far from deciding concrete controversies between actual parties, judges issuing non-party relief seem to be acting as counsels of revision, roving across the Federal Register to assess the legality of executive action before it can take effect. But our Constitution's framers affirmatively rejected that idea. It was proposed at the Philadelphia Convention that, quote, the judiciary ought to have an opportunity of remonstrating against projected encroachments on the people. Recall my example from earlier. The district court in Chicago that held its ruling with respect to one city's grant application should apply nationwide because there was no reason to think the legal issues would be different. This is precisely what a counsel of revision would have done, and it is precisely what the founders rejected in saying no to that idea and establishing inferior courts. Federalist 78 envisioned that the judiciary would be the least dangerous branch to the political rights of the Constitution. Everyone knows that quote. But there's another quote. Hamilton reasoned that individual oppression may now and then proceed from the courts of justice. While that may happen, the general liberty of the people can never be endangered from that quarter. But here's the other key quote from Federalist 78. There was a caveat. So long as the judiciary remains truly distinct from both the legislature and the executive. When federal district judges range beyond granting relief to the parties before them and make nationwide policy, they are going beyond their role in acting as the executive or the legislature. The more life tenure judges act like policymakers, the less confidence the public will have in federal courts. History has shown the American people have a stubborn tendency to demand a say in the rules and the rulers that govern their lives. So one of the virtues of our system is that we may rid ourselves of our elected officials every few years if we do not like them, but not federal judges. They have life tenure, and that lifetime share of the governing power means federal judges must be modest in their application of that power. Humility is a necessary judicial virtue. In recent years, it seems that the third branch has lost all sense of itself. It will either rediscover judicial humility or lose the support of the people and force a constitutional crisis. Of late, we've heard much about how criticism of judges can undermine respect for the judiciary. The judiciary itself frequently offers this warning in response to any criticism of it. And that's no doubt a very important point. But it is also incumbent upon a judiciary that wants to avoid the rough and tumble of politics to refrain from injecting itself into our nation's political life by reaching beyond the cases and parties that come before it. So my final point is, what do we do about all this? But I think I've hit my time, so I will save that for the rebuttal or the further questions and give you my proposed solutions. Thank you very much.
Thank you, Jesse. Luke, can you find anything to disagree with?
Just a few things. Thank you, Your Honor. I do agree with Jesse. It's a great opportunity to be here. This is a very important and timely topic, and so I'm so glad for the invitation and that the Society is interested in discussing this issue. Jesse has very eloquently laid out a case against universal injunctions, and I would like to spend just a few minutes respectfully pushing back. When used appropriately, universal injunctions or non-party relief cannot just be an act that's appropriate, not just acts of judicial overreach, but in fact can be an essential safeguard of the principles that our Constitution stands for and that this society was founded to promote and protect. Let's start with the separation of powers. It's true, as Jesse mentioned, that the Constitution charges courts with deciding cases and controversies. And I acknowledge that in many cases, it will not be necessary to reach beyond the present controversy and the present parties and issue relief that goes more broadly to others not directly involved in the dispute. But courts are also empowered to enforce the Constitution as the supreme law of the land. And that means that when the executive branch acts in manifest violation of constitutional limits, courts are well within their rights to issue relief that not only redresses the plaintiff's injury, but also prevents violations of those same rights as to other individuals. Let's take the example of the birthright citizenship case that the Supreme Court is going to hear later this month. That case involves an executive order that is really more like a royal decree. The president has purported to deny citizenship to thousands of people across the country with a stroke of a pen. Multiple judges appointed by multiple presidents across the political spectrum have found that order to be blatantly unconstitutional under current law. It makes no sense to require each of the thousands of affected children and their parents to file their own lawsuits on a child-by-child basis, just so that other judges can reach the same conclusion. The same logic applies to other broad-based policies that burden speech or discriminate on suspect grounds. If a court finds such a policy to be unlawful, but limits relief only to the named plaintiffs, the same unconstitutional practice continues everywhere. In my view, that is not judicial restraint, it is judicial abdication. There's also been a suggestion that universal injunctions are a recent innovation. I don't think that's true. I suspect that Professor Trammell will expand on this point in his remarks, but the bottom line is that courts have long issued sweeping injunctions in cases where narrow relief failed to check systemic illegality. Think of the examples of desegregation or gerrymandering or some of the foundational due process cases. And more generally, there is nothing unusual in our legal system about the fact that a decision in one case may have benefits for non-parties. Collateral estoppel often means that parties or individuals who were not parties in an earlier case can nevertheless take advantage of favorable rulings in that prior case. Moreover, as Justice Kavanaugh pointed out last year in his concurrence in Labrador versus Poe, relief that isn't party-specific is a necessary consequence of our system of vertical stare decisis. If I win my case in the Supreme Court, other people don't need to litigate the same exact issue in their own cases. My win, the result from my case, controls the results in those future cases. The idea that non-party relief is historically ungrounded is especially odd in cases involving administrative overreach. All the way back in 1946, Congress expressly provided in the APA that unlawful agency action shall, quote, be set aside. Courts have long understood that language to mean that agency action, when it's void, lawfully can't be applied to anyone, not just the party that brought the lawsuit. I'm sure we're going to discuss today whether that established interpretation of the APA is in fact correct. I happen to think it is. But at a minimum, the existence of that long-standing consensus is powerful evidence against the idea that courts today are acting in totally unprecedented ways. Some object, and we heard this from Jesse just a moment ago, that universal injunctions undermine the benefits of percolation in lower courts. I think there's a kernel of truth to this criticism, but it's often overstated. The paradigmatic case for a universal injunction is one where the issue presented is purely legal, the answer is not fact-dependent, and it won't vary from jurisdiction to jurisdiction or party to party. Percolation adds very little value in such cases. Also, I would note that simply because an injunction is in place from one district court doesn't mean that other courts can't continue to consider the merits of the underlying issue. We've in fact seen that happen many times in cases involving universal injunctions, including the birthright citizenship case I talked about, the travel ban case, and the JAG grants case that Jesse mentioned. By the time that these issues reach the Supreme Court, they have often been very thoroughly ventilated by the lower courts, which provides the Supreme Court the chance it needs to fully consider the issues. And in any event, we cannot let process become paralysis. In emergency situations, when constitutional rights are at imminent risk, a universal injunction may be the only practical means of preventing irreparable harm to thousands or even millions of people across the country. Others worry that universal injunctions are susceptible to abuse, especially partisan abuse. Again, I think that there is a kernel of truth to that criticism. I worked in the Biden administration, and I can say it was frustrating to see plaintiffs rush to the Northern District of Texas every time the president announced some new policy. But I would note that the potential for abuse exists with respect to any remedy that a federal court can offer. That's part of the reason why our appellate court system exists. And moreover, I would submit that the solution to these concerns is not a blanket ban on non-party relief. The solution is a disciplined application of the standards for Article III standing and for granting preliminary and emergency relief. That includes requiring courts to adequately justify the scope of the relief and to exercise their authority with care and clarity. At bottom, universal injunctions are not about judicial supremacy. They are about constitutional supremacy. When the president oversteps, as many of our presidents have done recently, they shouldn't get a free pass to continue violating rights merely because they haven't been sued by everyone whose rights they are violating. The courts are not the first branch, but they are often our last refuge. We shouldn't disable them from defending liberty when that defense is most needed. Thank you.
Thank you, Luke. We'll hear from Michael next.
Great, thank you very much, and I'd like to echo the other speakers' thanks for being able to participate on this panel, as well as for all of you for taking the time out to listen to this discussion. So I want to begin by building on some of what Jesse said. Jesse brought up several of the arguments that have been raised against so-called nationwide injunctions, and I want to begin by saying, if you don't believe anything else that I say, the one takeaway that I hope to successfully urge you about is that calling them nationwide injunctions obfuscates the point and makes analysis unnecessarily hard. The question isn't, may a district judge enter an order that has nationwide effect? Of course it can. The question is, what is the proper focus of an injunction, particularly in a public law case where someone challenges an executive order or a statute or a regulation. And I would suggest the best way to think about this is in terms of the distinction between, on the one hand, plaintiff-oriented injunctions, an injunction tailored to protecting and enforcing the rights of the particular plaintiff before the court, which is consistent with traditional equitable principles, which is the way that federal courts typically work, versus defendant-oriented injunctions, where the main focus of the injunction is saying, you government defendant, you government agency, you government official are prohibited from enforcing this challenged legal provision against anybody, anywhere in the nation, even if they're outside of my jurisdiction, even if their claims would otherwise be subject to the law of other circuits. My main focus isn't defending the rights of these particular plaintiffs. My main focus is on you, the government agency. And I would suggest that for many of the reasons that Jesse articulated, as well as a few others that I'd like to get into, that the proper role of federal courts is issuing plaintiff-oriented injunctions rather than defendant-oriented relief. This leads naturally into the Article 3 argument. Plaintiffs lack standing to seek relief that unnecessarily extends to third-party non-litigants. And this makes intuitive sense to us in every other context. For example, if you imagine a damages claim against the government, if a government agent plows into a bus that you're riding on, you of course have Article 3 standing to sue for damages, to seek compensation for the harm that you've suffered. But in the course of that case, you can't say, oh, Your Honor, there was also another passenger on the bus, and I'd like to sue to get damages for her as well. I'd like to sue on her behalf to assert her rights. To the extent you want to seek relief on behalf of people who otherwise would be third-party non-litigants, of course, the proper remedy for that is a Rule 23 class action. But without taking that step to draw those third parties into the court, you couldn't sue the government for damages for other people who've suffered the same exact injury as you for the same exact reasons as you. And this principle also makes sense to us in the context of private litigation seeking equitable remedies. If Apple were to sue Samsung for patent infringement, for example, Apple would have standing to seek an injunction prohibiting Samsung from infringing its patents, but Apple couldn't say to the court, oh, by the way, Samsung is also violating or infringing Sony's patents, so give me an injunction as well to prohibit Samsung from violating anyone's patents or infringing anyone's patents. Again, everyone understands that Apple, among other things, would lack Article 3 standing to seek that relief. But when we bring these two factors together, when we have a case against the government seeking equitable relief, the question purportedly arises then, well, do nationwide injunctions or defendant-oriented injunctions somehow become constitutionally permissible? And I would suggest the Supreme Court has told us no. In Califano versus Yamasaki, the Supreme Court tells us injunctive relief should be no more burdensome to the defendant than necessary to provide complete relief to the plaintiff. And in that case, by the way, the Supreme Court specifically said, if you want to seek relief on behalf of third-party non-litigants, Rule 23 is the proper mechanism. In fact, Califano approved the use of nationwide class actions, which is something that later I would suggest the court cut back on. Similarly, in Duran versus Salem's Inn, the court said neither declaratory nor injunctive relief can directly interfere with enforcement of contested statutes or ordinances except with respect to the particular federal plaintiffs. So I would suggest that the Article 3 concern about unnecessarily issuing injunctions that unnecessarily go beyond what is necessary to protect the particular plaintiffs in a case raise serious Article 3 considerations. And so this raises the question, of course, that Luke raised, which is, well, what about third parties? What about people who can't go to court? And the answer is the mechanism through which court rulings, especially most Supreme Court rulings, protect third parties, protect most Americans, isn't due to the scope of an injunction. Instead, it's due to the stare decisis effect of those rulings. Once a court of appeals rules on an issue, determines that an executive order is unconstitutional, determines a statute's unconstitutional, that ruling has stare decisis force throughout the entire circuit. Once the Supreme Court rules on the issue, that ruling has stare decisis force throughout the entire nation. And so the Supreme Court has construed the Everts Act, going back to the early 1900s, as establishing a hierarchical, decentralized decentralized judiciary where one circuit's rulings are not binding on other circuits. And so I would suggest it's directly contrary to that structure of the federal judiciary to say, well, even though one district court's rulings don't have stare decisis effect anywhere else, and even though they do not have offensive, non-mutual collateral estoppel, I apologize for that mouthful, effects on anyone else, as the court said in United States versus Mendoza. Nevertheless, we're going to allow the court to issue an injunction as if its rulings did have the force of law across the nation. And I would suggest that that flies directly in the face not only of Article 3, but the structure of our judiciary. Thank you.
Thank you, Michael.
Alan? Well, thank you all very much. I'm delighted to be here. I think Michael and I have been sparring partners on this issue since 2019, I believe, and we were trying to count up. We have actually lost count of the number of times that we have jousted over this. I very much enjoyed these conversations. I think that they're very productive, and they get to some of the most essential questions about the nature of the judiciary and how the judiciary interacts with the political branches. So initially, I was quite happy to accept this invitation, but I also have to confess a certain amount of apprehension because I don't want our discussion about the nuts and bolts of equity, the tradition that we inherited from England, or any of these doctrinal conversations to obscure that we are not living in a normal moment. And I know that we're not all going to share the same perspective on a lot of the issues that we're discussing, but it is not normal, as Luke points out, when the President of the United States, with the stroke of a pen, tries to rewrite the 14th Amendment of the Constitution and upend jurisprudence that's existed for more than a century. It's not normal when the President of the United States is advocating theories of due process that would essentially say even American citizens can be spirited away with no hearing whatsoever. And it's not normal that the President is actively trying to avoid obligations under binding court orders. That's the context in which we are talking about all of this. Now, you might not agree that universal injunctions are a solution to this, but that's the context in which we are talking about the role of equity writ large, dating back more than 250 years, in fact, many hundreds of years before the existence of the Republic. With that in mind, I want to start with where I think that there probably is a lot of common ground. As I will often say when Michael and I are talking about this, we agree that these universal injunctions are not a course of first resort. They are not normal in themselves. They are, in fact, an extraordinary remedy. I agree with Jesse about a lot of the downsides, the fear about a lack of percolation, the problem of what I call one and done, the race to the courthouse, the first person to get an injunction against the government essentially shuts down all other litigation. The fact that it doesn't allow the government to continue to pursue its own vision of what the law should be. That's administrative non-acquiescence. I mean, kind of like non-mutual offensive collateral estoppel. That's a mouthful, but these kinds of wonky doctrines require our attention, and they very much are at risk if courts willy-nilly start issuing this broad relief. So I fully agree that these are extraordinary remedies. They should be applied in really careful ways, and that they are ones that courts should actually have reasonable guideposts on. So let me start with first a constitutional question, and then to get into some of these problems that a number of my co-panelists have already brought up. What I want to, if you take away nothing from this, even if you despise universal injunctions at the end of this conversation, what I want you to understand is that they don't implicate Article 3 itself. All of these other problems are essentially prudential in nature, as they've developed in a number of other contexts, including in equity, including in the development of non-mutual issue preclusion. So start with what the Supreme Court has said the equitable powers of federal courts entail. These are the equitable traditions that we inherited from England at the time of the founding. So what did equity look like then? At a very, very high level of abstraction, equity was there as a backstop when remedies at law were not sufficient, and as I'll say a little bit more in just a moment, when our political representatives are actively evading their obligations under the law. That is when equity can step up. Very specifically, there were bills of peace in England, again, predating the existence of our country. Now, some people have tried to say, well, bills of peace were more or less a proto-class action. That's not quite right. They really did accord non-party relief in a number of instances. Professor Mila Sahoni at Stanford has written a number of articles tracing the development of non-party relief, particularly in the 20th century. We see this even in opinions where Justice Scalia said, yes, of course we have these traditions dating back to Ex parte Young, perhaps even before that, this tradition of equity stepping up to hold government officials accountable. That same tradition traces through with the Declaratory Judgment Act. We see it in all sorts of other procedural innovations, prophylactic injunctions, for example. And even the thing that often is held up as the alternative to universal injunctions, the 23B2 class action, the injunctive class. All right, that's an innovation from 1966. So all of that is to say that equity has very much countenanced non-party relief. It's ebbed and flowed, but again, that is very much the nature of equity. On the specific point of whether there is a case or controversy, a universal injunction is not going to offend the case or controversy requirement of the Constitution. When you have, for instance, in the birthright citizenship case, individuals or organizations who have standing to get into court, they are bringing a live case or controversy, they are establishing standing both as to the injury that they are articulating, as well as the form of relief that they are seeking. So all of that looks like a live case or controversy. The only problem is the remedial question. And the Supreme Court has long kept these justiciability issues, threshold questions, who is allowed into court, distinct from the remedial question. The Supreme Court has long done that, and it makes sense because you can't really know what the appropriate scope of relief is until the plaintiff has actually proved the plaintiff's case. And I want to actually stick with one of Professor Morley's examples. Imagine that a bus hits you, and you sue for your own individual damages. Well, if the court accords more relief than you have shown, let's say that I show $100,000 in actual damage, and the court awards me $1 million. Well, that's going to get reversed on appeal, not because somehow the court was acting without jurisdiction, but because the court made a mistake. It is simply reversible error. And that's the same thing that I think is going on here. If a court issues a remedy that is too broad, the appropriate response is limit that remedy on appeal. Don't somehow involve Article 3 by retconning a jurisdictional problem. I can say more about that during the Q&A, but I want to move into what I think are the very well-taken criticisms of universal injunctions. Some of the ones that I was articulating just a couple of moments ago. The fear of freezing the law, thwarting percolation, not allowing the government to pursue its vision of the law. All of those are prudential considerations that we see in the context of non-mutual issue preclusion, particularly offensive non-mutual issue preclusion. We can add to that fears about asymmetrical preclusion. And what courts have said over the last couple of generations is that those are legitimate concerns, but we shouldn't throw the baby out with the bathwater. Just because those concerns can arise does not necessarily mean that non-mutual preclusion itself is a problem. And this is to Luke's point, that every remedy essentially can be abused. The question is, what are the appropriate bounds for it? Now, I've suggested that taking a page from the preclusion book, we can look at these various factors, and if they are not present, then that might start to give us an indication of when broad relief, including relief that directly and intentionally benefits non-parties, is appropriate. And I want to broaden that out a little bit more. In an article that I wrote 6 years ago, I said that perhaps the best indication of this is when government actors behave in bad faith. And I think this is what Luke was getting at when he talked about not just a situation where a plaintiff might have a credible claim, but where there is a manifest violation of law by the government. So think back to some of our darker periods. You can think back to the civil rights era when in the South you had school boards that were actively resisting their obligations under Brown versus Board of Education. Now, sometimes that came in the form of outright defiance. Sometimes that came in the form of a drip, drip, drip compliance with one particular plaintiff coming in front of a court and a school board according relief just to that one plaintiff. So, in 1966, there is the innovation of the class action. By the way, it's a little bit strange, don't you think, to say that a provision that was adopted in 1966 proves that universal injunctions are unconstitutional. That probably is not right. I do think that it suggests that there is usually a far superior way to deal with these problems of aggregate harm and aggregate relief. Yes, we probably should be embracing class actions way more readily than we do. Again, universal injunctions are not the fallback that we should rely on in the first instance. But when there is evidence of bad faith, when you see government officials actively evading their responsibilities, sometimes law is not there. That's in many ways one of the insights of Ex parte Young. When government officials are actively avoiding their obligations, equity sometimes does have to step up. It sometimes does have to provide an extraordinary remedy, but I would suggest that in times of extraordinary lawlessness, an extraordinary remedy can be appropriate. Thank you.
Thank you, Alan. Tyler?
Thank you, Judge, and again, I'd like to say thanks for being here. Judge mentioned batting cleanup, but I don't think he meant in the baseball sense or in cleaning up something that's messed up, but more like when your older brother plays with his friends and then the younger brother's asked to come and clean up afterwards. So I want to take a little bit of a different direction and talk maybe to the TRO specific issue, the temporary restraining order issue. So I'm going to talk a little bit just kind of what a temporary restraining order was doing historically and how we got to what temporary restraining orders are today. Some questions on the appealability of TROs and how that might interact with the scope of those TROs, and then touch briefly on a problem that comes up, it maybe is most clear with non-appealable nationwide TROs or non-party relief TROs, and talk about kind of the structural implications of that I think we've seen in the last few months of the Trump administration. So first, the temporary restraining order has been around in some form for a long time. A party goes to court, files a bill for an injunction. If the idea is, the plaintiff I'm about to suffer irreparable harm and need an injunction, of course, waiting months or even years for adjudication of that claim might risk that irreparable harm before we can even get to a final decision. So we have temporary or preliminary injunctions. They were somewhat interchangeable, but maybe precisely temporary injunctions were shorter lengths than those of the case. Preliminary injunctions were generally, once they were entered, by default, they went to the end of the case. But the terminology is maybe a little bit less important. And a species of this temporary injunction was an injunction to maintain the status quo while we're deciding whether to put into effect a longer-term injunction while we're deciding the final injunction. And it's not until really 1872, there are a handful of instances that's mentioned, but it's not really until 1872, until a congressional statute comes, that we start calling these temporary restraining orders as something different, as a particular type of temporary injunction. So in 1872, there's a statute that specifically authorizes the temporary restraining order, and the mechanics of that were that the plaintiff would file a notice of a motion with the court for one of these preliminary injunctions or temporary injunctions, and then the court today we might think of this as like the summons. Sometimes you file the complaint and have to get the summons from the court. The court would then play a part in serving this notice of the motion, and could sua sponte, either by request of the plaintiff coterminous with the notice of the motion, or sua sponte, issue a temporary restraining order with the notice of the motion, right? So almost by logical necessity, all of these temporary restraining orders were issued without any involvement of the opposing party, most of the time before the opposing party even knew if there was a motion for a preliminary injunction was being filed. Now, the standard for that was if the district court decided that there appeared to be a danger of irreparable injury from delaying the order. So at least kind of in the late 1800s, there's no merits analysis to this temporary restraining order. And then there were various rules later becoming codified in various statutes and the rules of civil procedure, but there were just unwritten equitable rules about kind of expediting this process to decide the preliminary injunction, in part because of this no notice, no merits based order. But the idea being there's got to be some kind of pause. It's almost, maybe this is the wrong kind of parallel to draw in this crowd, but it's almost kind of like the bankruptcy idea, right? Where it's like, we just need a pause on everything real quick. We can get this worked out, but we can't get this worked out in enough time to really be doing justice to the case at issue. Over time, the statutes and the Supreme Court equity rules, which are the precursors to the rules of civil procedure that apply just to equity, start referring to a temporary restraining order as something that could be issued generally, but then was limited if there was no notice being given to the opposing party. Then eventually lower courts start applying kind of even before winter, but for sure after winter. The lower courts start applying a merits-based analysis, kind of the four-part test, which requires a merit-based analysis. Rule 65 in the 1940s requires notice to be given in almost every case. If not, then you have to certify why notice is impractical, even kind of some informal notice. To where today, most TROs, the vast, vast majority of TROs, are issued after a hearing, after notice and a hearing. And on a lot of these public law issues where the nationwide injunction comes up, all of the evidence is offered at the TRO stage. Most of the arguments are offered at the TRO stage. We see this if you look at some of the district court orders the district courts who have issued a TRO and then issue a preliminary injunction. Often the preliminary injunction order says, well, I've already rejected this argument in the TRO order, or the temporary restraining order. Therefore, I'm going to continue to reject it now. And really, and again, this is not meant to be a kind of a motive attack, but the TRO often serves the function of allowing the district court to write the preliminary injunction opinion that will then be the subject of appeal, as opposed to really, we need the TRO in order to consider the preliminary injunction opinion. The TRO is kind of the consideration that the district court has given to the issue. So now we'll turn a little bit to the appeals and why it is generally accepted that TROs are not appealable. So in 1892, so again, 20 years after kind of temporary restraining orders become a kind of a concrete idea, we have the interlocutory appeal statute, which for the first time, at least in federal court, allows for appeals of interlocutory orders concerning injunctions, and exactly what they had to be concerning injunctions have flowed over time, but now there's a long list of, I think they're adverbs, if I remember my 9th grade grammar class correctly. Basically anything concerning injunction, a preliminary injunction, is appealable. So why do people think that temporary restraining orders, which again were just a small species of a temporary injunction, why do they not fall within it? Well, in 1892, the statute required that the order be issued upon a hearing. And again, in the late 1800s, temporary restraining orders by logical necessity were not issued upon hearings. And so occasionally, when courts issued TROs, but for various reasons there was a hearing, often this came around with motions to dissolve a TRO, and there's a hearing on that motion, then courts heard the appeals initially. Now, as time went on, all TROs have hearings, but the general rule has been that TROs are not appealable. In 1948, Congress takes out the hearing requirement, but again, the kind of the courts go on in this kind of idea that TROs are generally not appealable. And now it's very complicated, again, kind of what that means for today with stare decisis, and if Congress takes out a word in the statute and then recodification into the U.S. Code in 1948, and no one notices, does it make a sound, right? Lots of complicated questions on that front, but I think as a practical matter, if a TRO is issued, particularly a TRO that governs non-parties, that's applied to an entire government program, that's then not appealable, right, that's going to create more and more of the angst that we heard Jesse and Michael talk about, and even Luke and Alan, about kind of this idea that the one district court, in this case, non-appealable district court, is, even if just for a few weeks, kind of completely able to stop government programs. Now, to be sure, I think if you follow the recent court cases and the emergency docket and some of the Trump administration appeals, sometimes the courts have allowed appeals from TROs. Now, despite them saying that that TROs are not injunctions that are appealable, I think that courts long have kind of recognized that some TROs kind of look so much like preliminary injunctions, the purpose of not making parties wait to get appellate review are implicated. But the current legal test requires something that approximates, different circuits apply different tests, something that approximates irreparable harm. So, meaning that in a case where the TRO is issued, the plaintiff has to show irreparable harm in the district court, then the defendant has to go to the appellate court and show that the temporary restraining order will or has caused irreparable harm to them. And in the end, that's a jurisdictional inquiry where we're deciding the irreparable harm of a temporary restraining order, and we're kind of just, again, kind of putting competing value claims together where the plaintiff and the defendant are both claiming that irreparable harm puts them on the side of, or puts them on opposite sides. So that leads me to my final point very quickly, which is, courts long have been the traditional bulwark of liberty, but in a sense of kind of my individual claim of right, it allows me to come and bring the government official before the court and on equal terms. I get to assert my claim of liberty with a neutral arbiter against the government. But nationwide and especially non-appealable temporary restraining orders or non-party specific temporary restraining orders make it seem less like an individual is litigating the government and more like two branches of the government are fighting about the legality of a certain policy. And not just two branches in some instances, if it's non-appealable, one district judge versus the executive. And so I think we see this in this Trump administration where there's been a pull to make this about the judiciary versus the executive, and that's more plausible in cases where there's nationwide relief or non-party specific relief, and less plausible in cases where it's about one individual against the government, because I think we all kind of see that we want the judiciary to be something that we can go to when the government turns against us. But it becomes more and more plausible to make this a branch versus branch fight and lose track of the individuals that are involved in the litigation. Thank you.
All right, thank you, Tyler. Thank you to my panelists. All right, we have about 20 minutes left, and so if I give everybody 4 minutes, we will have no time for questions. And I have a question that I want to ask, and I want you to be able to ask questions too. So we have 2 mics, so go ahead and line up to the mics. I'm going to ask my question first. We're going to skip over the rebuttal time because everything has been said that could possibly be said, I feel like. Not really, but I think my question, hopefully maybe could any of the panelists or all the panelists could have some thoughts on this. On one hand, we would have we have kind of extremes here. One would be the Supreme Court stepping in, maybe in this birthright case, and saying no more national or universal injunctions. And on the other, at the other extreme, you hear talk of people saying this administration should stop following what these judges are telling them. And both those seem to be at one extreme or the other. And I'm trying to figure out if there's anything in the middle, and that's what so for the administration, is there something less extreme the administration could do to, if you're advising this administration, you've heard it said, the idea that the administration would say, we've got an injunction from a district court, we're going to follow it for 30 days, but we're not going to follow it nationwide after that unless the Supreme Court steps in. So trying to put a little pressure on the Supreme Court to have to step in. I don't know if that's a good idea or not, but it's just, something less extreme than just saying we're not going to follow what the courts say. And so it's something like that or something different. And from the Supreme Court's perspective, I think Alan and Luke both mentioned. I wrote down Alan saying something we're not in a normal moment, and I think that's definitely, you can tell that is a feeling behind a lot of this, and I think Luke said something about manifest error. We're talking about, so I don't think anybody here thinks that you should have nationwide injunctions in the ordinary course, so to speak. It's more like an emergency, whatever that word means. But I think that on the other side, people think, yeah, but these judges are seeing an emergency every time Trump does something or something that's not normal, and so that's a little bit in the eye of the beholder. So the question is, what could what could the Supreme Court, without getting rid of nationwide injunction or universal, what could the Supreme Court do to try to put a little more skin in the game for, because remember our founders, they believed in structural, not just, so you can come up with O'Connor's, 14-step tests and that does nothing. So what can you do structurally? And so I think about it, you could say, if you issued a nationwide injunction, you have to shoot your dog or something like that. That would, I suppose, make it so that judges had a little more skin in the game for some judges that like their dog or something like that. But that's probably, I don't know where that would come from. So another thing you could do is, could the Supreme Court take a really egregious example and, if there is one, and I realize that's not eye holder, but remove the judge from the case? Because in my experience, judges do not like. We have life tenure, right? There's not much you can do to us, but for some reason we care a lot about our reputation. At least most of them do. And so if you got removed from a case, my thought is that you would take that really seriously as a district court judge, or maybe even say removing you from the case and referring you to the circuit court to see whether or not you have bias against this administration such that you can't sit on any more cases for the rest of the time this administration's in or something like that. You wouldn't have to do anything to change, you wouldn't have to have any doctrinal changes to our nation. But would that, these are just things that I've, thought about. I'm sure the panelists could think of it. But is there anything less you could do from each branch? And this what really is sort of a fight between the branches, separation of powers. Is sort of the way our Constitution structure was designed. But what can they do that's not at the far extreme? Any thoughts on that? You don't have to comment on the shooting the dog thing. That was just something I said on that.
Well, I'm happy to comment on it. I mean, I think there's a few questions there. One is, can the Supreme Court take any half measure? I mean, I personally have no confidence that the Supreme Court is ever going to address this issue in a serious way. I think it's in the nature of separated powers for branches not to check themselves, and this has been going on for 20 years. This issue's come up again and again and again, and the court either hasn't been willing or able to address it. So my own view is, this is a check and balance time, and I think it's time for Congress to act. There's a bill that Senator Grassley introduced that I think is a good bill. In my view, there's really three things that Congress would need to do to check this, but they're not half measures. I mean, they're addressing the problem directly. One is amend the statutes to make clear that federal district courts do not have this jurisdiction to issue relief to parties not before them. Two, because of the trend in, what I think district courts are doing now is knowing that they might get appealed on preliminary injunction, they're issuing these shadow preliminary injunctions and calling them TROs and then extending the time and extending the time. It needs to be clear that those are immediately appealable. Anything that is in the form of injunctive relief needs to be immediately appealable. And then three, I think there's one more reform, which is, assume we get all this, assume either the Supreme Court or Congress says you can't do this anymore. Here's what's going to happen. Judges are going to say, I'd like to give nationwide relief. I can't do that anymore. How about we certify a class in 5 minutes? They're not going to do what the class action system has meant, which is a rigorous review process, making sure they're standing in adequate representation. So I think the Attorney General needs the ability to certify when an injunction against the government raises a question of national importance. And when the Attorney General so certifies, it is mandatory jurisdiction for the Supreme Court. No more ducking these cases. If you want to have this kind of system where district judges get to act supreme, then the real Supreme Court is going to have to act as well. They can't duck it on, it's on the emergency docket and it's not the right procedural posture. They need to take these cases and decide them. If they're really emergencies, if they're national emergencies, then the highest court in the land needs to decide the legal issue and stop ducking it.
I think if you throw around the words mandatory jurisdiction, the Supreme Court might actually be motivated to do something because they really don't want that solution. I do think they have an array of options on the table. The one that seems to me to be the most promising is to crack down on Article III standing. We've had a number of cases, I think I counted 5 or 6 in recent terms, where there has been a nationwide or universal injunction that was issued, and the Supreme Court has ultimately said that the plaintiffs there didn't have standing, and that was the way the case was resolved. So I think, and this goes a little bit to the judge's point, if the Supreme Court were more vociferous about the importance of standing and maybe a little bit of shaming for judges who are inappropriately expanding standing to allow plaintiffs to bring suits that they shouldn't be bringing, that might be an option. But I also agree with Jesse that ultimately the ball really should be in Congress's court. This is an important question that to me seems to be exactly the sort of policy issue that Congress should be grappling with. Congress has tools the Supreme Court doesn't have. It can have hearings. I know Jesse has testified at some of those. It can collect data. It can consider the equities of the situation and come up with different alternatives. Jesse has listed a couple of options. Others I'm aware of are suggestions to randomize the way that these cases are decided. So you could have, for example, a 3-judge court in the same way that we often have for election litigation that is assigned to do some of these emergency cases. You could also think about something like the JPML, the Panel on Multi-District Litigation. If you have issues that truly have nationwide effect, maybe you randomize the way that these issues are assigned to judges so that you don't get the sort of forum shopping concerns that we've seen. So I think that there are a lot of options between never having these injunctions on the table and having them come up routinely, as I think the administration feels they have. But ultimately, I think that's a question for Congress and not for the courts.
I'll just add, oh, sorry, Mike.
No. So I think that there are some options that the court itself could consider, which would alleviate potentially some of the perceived need for courts to be issuing these or so-called nationwide injunctions or defendant-oriented injunctions. One possibility would be to afford a degree of stare decisis effect to district court rulings, whether that be within that district, within any districts within that state, or I would not certainly go further than the circuit to the extent that the district court is bound to apply the law of that circuit, but not other circuits. Right? One of the main arguments that comes up in favor of the sweeping relief, right, is the need to protect third parties, and I think that a lot of the debates over whatever you want to call them, right, nationwide defendant-oriented injunctions, misses the fact that there are other aspects of court rulings that typically provide protection for third parties. And so allowing district courts to protect third parties through the mechanism of stare decisis, I think, is more consistent with the structure of our judicial system, puts a cap on that sort of indirect effect of district court rulings, and I think you need to shoehorn that into existing doctrine to a far less degree than you do nationwide injunctions. I also, to elaborate on another point that Jesse made, we're talking about one particular type of order here where the court unnecessarily goes beyond giving relief to the particular plaintiffs before it, but many of the objections to that order equally apply. Not all of them, of course, but many of the objections to that order equally apply were the court to provisionally certify a nationwide class. Or in many cases, you'll have groups asserting associational standing or organizational standing where they're in effect seeking to completely suspend invalidation of a statute, claiming that they as an organization, either they themselves as a group or their members for associational standing cases, are going to suffer harm if the statute is enforced against anyone anywhere. So to the extent you think there are concerns about traditional nationwide injunctions, the mechanism for resolving them shouldn't open the door to these other sorts of orders that raise many of the same types of concerns.
I will simply say that the Judicial Conference is also there. They have even more tools in some ways than Congress does at its disposal, and the Judicial Conference is really, really well situated to take on board all of these comments and to translate in this specific context the traditional role of equity into a modern application. We saw that with the 1966 revisions to the class action rule.
Yeah, small note on that. I was just going to say the Supreme Court's maybe their other role as the court that promulgates the Federal Rules of Civil Procedure. There's nothing magical. This kind of maybe goes against what Michael was just saying, but there's nothing magical about the current Rule 23. In fact, it's much more narrow than equity was at the founding, than the original kind of equity rules in 1850 and so on. And to the extent that we're kind of worried about the proper judicial role, it would not be inconsistent with that proper judicial role to expand class action more. And really then the problem comes down to kind of the increased role of equitable suits against officers and kind of the ex parte Young innovation and explosion.
Thanks, Tyler. Well, let's go to the first question here up front.
My question is to those that oppose nationwide injunctions. And if you are a consumer and your argument is that the federal government is regulating industry and then indirectly harming me, I don't see any way that you can have an injunction that applies only to the parties when you have that kind of indirect harm. And states often have these kind of indirect harm claims on how they are injured. The regulation of the people in this state are causing indirect harms to the public fisc in the state. So even assuming that you're right and the Supreme Court narrows it only to the parties is to provide complete relief, I don't necessarily see how you can get away from the kind of nationwide injunctions.
Can I jump in on that? So I think you're absolutely right, and I think the answer to your question hinges on the distinction between what the American Law Institute refers to as divisible versus non-divisible rights. And this goes back to why I think it's actually more helpful to frame this dispute in terms of plaintiff versus defendant-oriented injunctions. If a court is issuing a plaintiff-oriented injunction, it may very well be that, as you point out, it is impossible to give the plaintiff full and adequate relief without, in effect, issuing an order that winds up indirectly benefiting third parties as well, and that's fine. The real issue is, what is the court's focus? Is the court focused on giving this particular plaintiff relief? And if that plaintiff's rights happen to be indivisible with the rights of third parties, then that's fine. But in situations involving divisible rights, in situations where a court can enforce the rights of the particular plaintiffs before it without having to necessarily go further and enforce the rights of third-party non-litigants, that's where I think the rubber hits the road. And as a practical matter, you would see a tangible difference in the type of order a court issues with a nationwide injunction versus not, or a plaintiff versus a defendant-oriented injunction.
All right, thank you. In the very back there.
So there are advantages and disadvantages to class actions. But one of the advantages is, even if there are extraordinary damages, in return you get global peace. It applies to all. It applies to all plaintiffs, class-wide.
I think we're having a little trouble hearing you, so get up close to the mic if you don't mind.
There are advantages and disadvantages to class actions, but one of the advantages is that when it's done, you get global peace. The plaintiffs are foreclosed from bringing further actions. With nationwide injunctions, isn't there a real problem that only the government ever loses? Because if the plaintiff, even if the government is successful in one case, plaintiffs run to district after district after district until they get the nationwide injunction that they want.
Well, I'll even jump in and say yes, that's absolutely right. And it's something that Professor Morley has pointed out in a lot of other contexts. It's this problem of asymmetrical preclusion. And in the preclusion context itself, that is one of the key reasons why non-mutual preclusion would be denied. Actually inconsistent judgments, this fear that no matter how many times the government wins, even a single loss can negate all of those victories. That is legitimately a problem, and I think that very much carries over in the universal injunction context as well. I would say that when those and all of the other prudential factors are not really there, when there is this pressing need, say the speed of a particular issue where you don't have time to conduct a class certification hearing, then perhaps broad relief could be appropriate. But in the mine run of cases, I think you're 100% right.
And let me just add to that, that is exactly right. That's a real problem where the government, can win 999 times and lose once, and it loses nationwide. But it's not just a problem for the government. I want to be clear. This is a problem for the judicial branch, because what is happening, let's go back to that grant case I was talking about. A senior judge in Chicago said, I am enjoining the grants nationwide. The Second Circuit said, these grants are legal. These conditions on the grants are legal. That senior district judge in Chicago said, I do not care what 3 appellate judges in New York have to say about the law in New York and that circuit. My ruling applies, even if they won. There's a real judicial comedy problem with that. There's a real structural problem, because we're supposed to have a hierarchical court system. So it's not just with the government, it's what are these judges doing in relation to each other. That is one of the issues with these rulings.
All right, we're about out of time, but I'll take one last question here from the front.
Hans von Spakovsky. Unless I missed it, I'm astonished that there was no discussion of one of the key precedents in this case. Luke McLeod, you mentioned collateral estoppel as a justification for for nationwide injunctions. In U.S. versus Mendoza, the U.S. Supreme Court specifically said that collateral estoppel does not apply to the government. It applies to private parties, but not the government. And as Professor Trammell, I'm sure knows, that case also involved citizenship. But the Supreme Court said that an adverse judgment against the government in one case only applies to the named parties, does not apply to anyone else. The government can relitigate that issue. I mean, are you saying that all these judges who are violating that precedent, that they are justified in doing so?
No, I'm not taking that position. We were actually just talking about Mendoza during lunch. It is a really good precedent for the government, and I think that, to the points that Jesse has made, there are concerns about the way that this is being applied against the government. I think a couple of thoughts about Mendoza. One is, as we were discussing, it's not clear to me that that's actually a constitutionally required rule rather than something the Supreme Court just made up as sort of a matter of common sense. But even setting that aside, I think the value of the analogy to a collateral estoppel is that it shows the concept that you might benefit from a ruling you weren't a part of is not alien to our law in the way that defenders or opponents of universal injunctions have suggested. This is something that happens. It may be that the rules are a little bit different when it comes to the government, but the idea that a federal court can never issue a ruling that will benefit a non-party just isn't true, and the collateral estoppel doctrines show that.
All right. Well, thank you, Luke, and thank you to all my panelists. I think we solved all the problems about universal injunctions today. Thank you all for coming, and we'll break.
Good job.
We'll start the next plenary session across the hall in 10 minutes. Thank you all.